Okay, well, good afternoon or good morning, of course, depending on where you are in the world right now. Welcome to this session. My name is Lior Samfiru. Mouthful, I know, but you get used to it. I'm the employment lawyer. I'm one of the founding partners of Samfiru Tumarkin LLP. We're the largest employee side law firm in Canada, and I'm here for one purpose and one purpose only, as I am every week. It's to answer your questions. It's to tell you what you need to know about employment law, is to make sure that you have some solutions, some guidance with respect to your workplace issues. So if you're dealing with a tough situation, you have an ultimatum, you lost your job on a leave of absence, mistreated at work, whatever the issue, whatever the problem, just type in the question right now, press enter, I'll see it, and you'll be able to walk away with some answers today, right now. So again, my name is Lior Samfiru. I'm the employment lawyer. And let me give you another a way to contact me if you want, before we start with the question. So if you want to reach out to me off air, if you want to have a chat personally, privately with me or my team, easy. All you do is you go to employmentlawyer.ca. You see that address below me, employmentlawyer.ca. You'll see the phone number, the email address, forms. It's all there. You can contact me directly. So if you need to follow up, don't wait another week till I'm back. Do that now as soon as possible. And right now, I'm going to start answering questions. I'm the employment lawyer. You're here to listen to employment law issues and questions and answers. So ask your questions, take advantage. So let's start off. First question from Lena on YouTube. How exactly do we treat a leave of absence as a termination? So you can't do that. We have to do that. So if you're put on a leave of absence, an unpaid leave of absence, you can choose to treat that as a termination. And the way we do that, we have to get involved. We have to send some documents to your employer, essentially outlining that we're not accepting the leave of absence, that that's a termination, and they have to pay severance. So we have to engage your employer. There's not really something that you can do on your own. We call this a constructive dismissal. Now, if you're part of a union, I think you mentioned here union, that doesn't apply to you. You cannot do that if you're part of a union. Only the union is allowed to help you in that situation. You have to talk to your union. So that's a good time to remind everyone that everything you hear on this session, everything, only applies to non-union employees. It does not apply to unionized employees. If you're a unionized employee, you have to talk to your union. There's no other options. There's no exceptions, okay? So hopefully that's clear. Next question I'm answering. Hey, I'm Lior Samfiru. Ask your question. What's the difference? Sorry, this is from Dole W. Drew on YouTube. What's the difference between a law and a mandate, and will any difference affect how court cases are settled? You don't deal with union members, but are unions obliged to have lawyers for grievances? There's really no difference between a law and a mandate. Certainly not when it comes to vaccines. So what I mean by that is if the government implements a mandate that applies to your employer has to comply with it. There's no choice there. So the only time you don't have any option is if there's a mandate that applies to you. Now, you're asking about unions. Yes, unions do have lawyers to file grievances, but it's up to the union to decide if they do that. And if they choose not to, there's not much that you can do. Okay? Next question today from Laura on Facebook. Do bonuses get factored into severance, or is it only based on base salary? Terrific question. Bonuses absolutely have to be factored as part of severance. So your severance has to account for all components of your compensation: salary, bonus, benefits, car allowance, commission, pension, you name it, they all has to be included. So for example, if you usually get a $10,000 bonus a year, as an example, and let's say you're owed 9 months severance, okay, then you get 9/10 of that bonus, whatever that comes to, or 9/12, I should say, of that bonus. It's prorated. So absolutely, bonus has to be, and I've spoken with hundreds of people over the years where the employer conveniently forgot to include the bonus, the commissions, the benefits, what have you, and the difference can be huge. So when it comes to severance, it's not just the number of months you're owed, it's not just your salary, it's not just your benefits, it's everything that has to be included. So thank you for that, Laura. On YouTube, next question from JC2004X. Do severance entitlements affect EI eligibility? So the answer is yes. Here's what I mean by that: is you can't you cannot get EI and severance for the same period of time. So if you're let go now and you're getting 6 months severance, as an example, well, you can't get EI for 6 months because you're getting income. So it does impact it in that way. But oftentimes we're able to negotiate an arrangement that allows you to have both. But yes, it does affect it. I'm going to continue answering right now. Lots of questions. I love that. For those joining, first of all, welcome. I'm Lior Samfiru, the employment lawyer, and I'm here to answer your questions. If you want to ask questions, ask them, type them in, and I'll see them. Of course, you can also always go to employmentlawyer.ca. Again, employmentlawyer.ca. If you want to connect with me off social media, you see that address right below me. But right now, back to questions. Question on Facebook from Yvonne. I'm a seasonal worker for a municipality and was told that I would not be able to come back to work in April unless I was double vaccinated. I'm not willing to comply with that. I have a pension with the municipality. Will I lose this because I choose not to be vaccinated and they are letting me go? So first of all, this all assumes you're not part of a union. Okay, you're not part of a union. If you are, then you have to talk to your union. If you're not part of a union, then in your situation, if they won't bring you back, that's a termination and you are owed severance. Now, I don't know how long you've worked there, so I can't tell you how much severance you're owed. So you don't lose your pension. In fact, they have to contribute to your pension for the time period that you get severance. So if you're owed 12 months severance, they have to continue contributing to the pension for 12 months. Now, you can take the money that's in the pension and transfer it to another financial institution or financial vehicle, like an RRSP or anything like that. So you can do that. You don't lose the money that's in the pension. Now, if and when that happens, Yvonne, I want you to contact me. If by April, because who knows what April looks like, it could be different. But if by April your employer still says there's no job for you, you need to contact me. They're not going to pay you severance without us pushing them. So let's do what we have to get you that severance. And to contact me, Yvonne and anyone else, employmentlawyer.ca. All right, good questions today. Next question from Joey on YouTube. Once the employer verbally terminates me, can I deliver an insult, or can that be used against me? Don't deliver an insult. It makes no sense. Can it be used against you? Arguably not if you've already been terminated. But here's what's going to happen. If your employer terminates you, right, we're going to be engaging your employer to get you severance. So do you really want to unnecessarily upset the person that we're trying to get severance from, that we're trying to negotiate as much money as possible from? Don't do it. Bad idea. All right, next question from M. Young on Facebook. For unionized employees, when can we contact a private lawyer for help? No, you cannot contact a lawyer. Even if the union's not doing their job, you cannot contact the lawyer for help. The only thing you can do if your union won't help you is you can try to file a complaint against the union with the labor board. The chances of that succeeding is very small. So you cannot hire a lawyer to deal with your employer ever. Okay, even if the union doesn't do a good job, even if you tried, you cannot do that. That's the problem with being unionized. All right, next question from Everything Aryan on YouTube. My religious exemption was denied. I'm on my way to termination. However, I am asked to complete an educational webinar. Do I have to if they're terminating me anyway? Do it. Absolutely do it. You don't want to give your employer any ammunition to say that you were somehow insubordinate. Okay? Do your job. Do everything they're asking you to do until they terminate your employment. Continue working. Be the best employee you can be until that happens. When your employer terminates you or puts you on a leave of absence, contact me. Contact my office. Let's get to work to make sure you're compensated. Okay? And of course, to contact me, to contact my office, to contact my team. We have a whole team across Canada. Easy. You just go to employmentlawyer.ca. Again, employmentlawyer.ca, and we'll get to work. Let's see. Next question here. By the way, the employment law session right now, you're here listening to Lior Samfiru answering your questions live. Okay, I'm live. So ask your question. Question on Facebook from Julie. My employer required me to get the vaccine, which I did, and now I have an injury as a result. Now they're requiring the booster for me to keep my job. Can they do this? Well, they weren't really able to require you to get the vaccine to begin with. So here, the real question is not, are they allowed? The real question is, what happens if you refuse? If you refuse, they will likely let you go. They will, okay? You can't physically stop them, but they're gonna have to pay you severance and potentially other damages as well. So the question that you have to ask yourself then, Julie, is, are you willing to lose your job? Because there's no way to stop that. The fact that it's illegal doesn't mean that you can restrain them. You can't go to the police and say, police, stop them from letting me go. They will let you go, but you're going to be owed severance. You would have been owed severance even with the original vaccine. Okay, so that's really what it comes down to. Are you willing to lose your job? If you are and you choose not to get the vaccine, they'll let you go. They won't offer you severance likely. We'll need to get involved to get you that severance. Not a big deal. We've been doing it for hundreds of people across Canada. So when that time comes, just contact me through employmentlawyer.ca. Okay, good. Next question from Errol Airy Pages on YouTube. Vaccination that's not in your contract cannot be enforced. Is it illegal to discipline an employee who was hired without requiring vaccination? So again, you're looking at the wrong way. When it comes to employment law, when you say something illegal is illegal, there's no way to stop it. Okay, it's not a criminal activity. You know, there's ways to. If there's a crime, you can go to the police. When it comes to these matters, you can't go to the police. So forget about is it legal. Forget about is it enforced. Think about what happens if you say no. If you say no, you will lose your job. I can almost guarantee you. But you're going to be owed severance. That's where we get involved. So don't, people get hung up, oh, they're not allowed to do this. It doesn't matter. They're doing it. You just have to decide what happens when they do it. So that's what the focus has to be. Not are they allowed, but what happens if? That's the question you have to ask. Next question on Facebook from Candice. You need to be actively looking for comparable job when we're going the legal route of wrongful dismissal. Yes. You need to be able to show that you've made some job search efforts. Now, you don't have to be looking for work 8 hours a day, 7 days a week. No, but you have to show that you've made some efforts. Absolutely. We call this the duty to mitigate. In other words, you do have an obligation, if you're seeking severance, to make some efforts to replace the income that you've lost. Okay? So yes, absolutely. In most cases, that's not a very difficult thing to do. Next question from the Dreamer on YouTube. If an employer gives you a verbal or written warning, but you refuse to sign off as understood it, can that still be used as for cause termination in the future if they're building a case? So the reality is that all you have to do when you sign, you're not agreeing that it's correct. You're simply agreeing that you've received it. You physically got the warning. There's nothing wrong with signing. Okay, it's okay to sign. Now, if you don't agree with it, with the content, then say so. Say so in writing. Send an email or a text message saying, here's why I disagree with the warning. Here's why it didn't happen this way. By doing that, you're going to make it much more difficult for the employer to rely on it. But don't worry about signing it. The signing simply says, sign here to acknowledge that you've received this warning. It's okay to sign. You did receive it. That doesn't mean you agree with it. That doesn't mean that you say it's correct. And if you don't think it's correct, just send an email telling them, here's why it's not. Okay, for those joining us, hey, I'm Lior Samfiru. I'm the employment lawyer, one of the founding partners of Samfiru Tumarkin LLP. We operate across Ontario, BC, and Alberta, and I'm here live, as you've seen, answering your questions. Still have some time, so post your question right now. Let's chat about it. Let's make sure that when this session ends, you have some answers, you have some direction and guidance. From Joe on YouTube. I understand that the law allows an employer to make minor changes to an employment contract without triggering constructive dismissal. How many times can they do this? Because cumulatively, these changes would add up to something very substantial. So this is a difficult question to answer because every situation is different, right? So there's no rule that can do this once or twice. It depends on the change, it depends on your job, and depends what your employment agreement says. So the best advice I can give is this. If you're facing changes to terms of employment, big cases, big changes or small changes, Let's talk about that. Let's have a chat. Let's talk the specifics. Let's talk how we respond. Usually the way I would do this is I would simply respond, employer, yeah, this is a change. I'm not happy about it, but I'll accept it, but I'm not going to accept future changes. So let's talk about that, but we need to actually look at the situation instead of talking hypothetically. Okay, next question now from RM on YouTube. I work from home permanently. Can I refuse the vaccine if they mandate it? Well, again, don't look at it as can I, okay? Look at it, what happens if they mandate it. If they say, we don't care if you work from home, if you don't get the vaccine, we're letting you go, they will let you go if you don't get the vaccine, they will. Now, that's a dumb thing to do if you're working from home permanently anyway. Why would they do that? It's dumb. But if they do it, there's still no way to stop it. You will definitely be owed severance in that situation, potentially other damages as well, but you can't stop that. So if they tell you that, you have to get the vaccine or else. The first thing you have to ask yourself, the only thing you have to ask yourself is, am I willing to lose my job? Now, I can tell you they shouldn't be doing that. They shouldn't. But you can't stop it. So you will lose your job, okay? You can't stop the employer from doing that ever, even if it's not a good reason, even if it's an illegal reason. You can't prevent them, physically prevent them. So that's why ask yourself, am I willing to lose my job? Okay. Next question from Tony on Facebook. What if your union is taking long or failing you? Unfortunately, there's no other option. That's the problem with being unionized. You have to follow your union. And if they're not helping you, you have to push and try to work with them. There's really nothing else that you can do. Okay. JC 2004 on YouTube. If a company can impose a vaccination policy, can they theoretically impose a policy stating that the employees don't vaccinate? Well, they can do whatever they want. They can impose a policy that says you have to cut your hair and be bald to work here, okay? Or that you can only wear blue shirts. They can do that. The question is, what happens if you refuse? And if you refuse and they let you go because you refused, you're owed severance, right? But the employer can say tomorrow, if you want to work here, you have to drive a Mazda. Okay? If you drive a Hyundai or a Toyota, you don't work here. It's a dumb policy, but they'll do that. But if you drive a Hyundai and you don't get rid of it and buy a Mazda, and that's why they let you go, they'll have to pay you severance. So that's the way to look at it. Okay. M. Young, I already answered your question about union. Let's see, what's the next question? From Muhammad on YouTube. What is a wrongful dismissal? Can a person claim damages for wrongful dismissal or letting go without any cause? So an employer can let you go without cause. It's a wrongful dismissal is about severance. If you've been let go and have not been paid your full severance or no severance, you've been wrongfully dismissed. So a wrongful dismissal really has nothing to do with the reason, okay? An employer can let you go for any reason, usually, as long as it's not a discriminatory reason. They can let you go because you drive a blue car, or they can let you go because they prefer people with beards instead of people without beards. You know, I'm being silly. But as long as they pay proper severance, it's fine. The reality is that 90% of people, when they're let go without proper severance. They've actually been wrongfully dismissed. So 90% of the people that lose their job are actually wrongfully dismissed. So for Muhammad and anyone else, if you want to know how much severance you are owed, you can find out in seconds. Here's what you do. You simply go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. We have our severance calculator tool. You see the address below me. You can answer some questions in the severance calculator and find out in seconds how much severance you are owed. You can use it now. It's free. It's anonymous. It doesn't record your name or any other information. Even if you haven't lost your job, but you're just curious or worried, go to pocketemploymentlawyer.ca and use our calculator, and you'll be able to find out now how much severance you are owed. So hopefully that answers the question, Mohammed. Next question from Alex on YouTube. What if your union is taking long or failing you? Unfortunately, there's no other option. That's the problem with being unionized. You have to follow your union. And if they're not helping you, you have to prevent them, physically prevent them. So that's why ask yourself, am I willing to lose my job? Next question from YouTube. I am Anna Bulili. For a favorite one today, favorite name today. If you're put on an unpaid leave by the employer, does severance cover the period of unpaid leave? No. So if you're put on an unpaid leave, you have a choice. Either you can accept it and wait at home and hopefully they call you back, or you can choose to treat that as a termination. So in other words, effective the date the leave started, you've been terminated and now you're owed severance. Depending on the factors, maybe the severance is 2 months, maybe it's 6 months, maybe it's 24 months. So it has nothing to do with the length of the leave. It's whether you choose to treat the leave as a termination and get severance. From Holly on Facebook. Has your firm taken any cases dealing with employees terminated for not getting vaccinated to court yet? If so, have those cases been successful? There have not been any court decisions. We have hundreds of cases that we're dealing with, but they're resolving, they're settling. The employers are backing down, and they're paying the money, so we don't need to go to court. Going to court is a dirty word, okay? Court, trial, that's a dirty word. You don't want to go to trial because trials are not fun for the individual. They're fun for the lawyers, but we're weird that way. The nice thing about these cases, all cases, is that 98% resolve, they settle, and usually very quickly. So I'm not proud when I say I went to court. In fact, I'm disappointed because it means that everything that I know how to do didn't work. Okay, it means that in a way I failed. Because my job is to get the matter resolved for my clients as quickly as possible and on the best terms possible. So if I do everything I can, I should be able to get this resolved well before having to go to court. Okay, so no, we haven't had to go to court. Yes, there's cases that could go to court, that takes time, but I expect that the vast majority are going to resolve on very good terms without having to do that. From Aaron, next question on YouTube, on Facebook. My employer asked my vaccine status yesterday. I refused to give it to him. Am I in my legal right to refuse without being reprimanded? Well, you will be reprimanded and likely let go. So it's not about am I within my legal right. It's a question of what will they do. They will treat you as unvaccinated and likely let you go or put you on an unpaid leave. It's going to happen, so you have to decide, Aaron, are you willing to lose your job or be suspended because of this? It's up to you completely. So again, forget about are they allowed. Forget about it. It doesn't matter when it comes to employment law. It matters what happens if they do it anyway. And if they do it anyway, you will lose your job, but they'll have to compensate you. And that's where we come in. Next question, I think it's a follow-up from Everything Aryan on YouTube. When I'm terminated for this vaccination policy, will that affect my ability to receive maternity EI? Yes, it may well affect that, unfortunately. Let's see. We have a couple more minutes, guys. See if you can squeeze in your last questions here. My name again is Lior Samfiru. I'm the employment lawyer. Janice Murphy on Facebook. I have been put on an unpaid leave until January 31st. Then they will advise if they are extending or if I'm going to be able to work. Can they just keep going with this? I can't get EI because I'm on unpaid leave. Can you give direction? Well, you can already choose to treat this leave as a termination. You don't have to wait till January. You can say, now, because you put me on the leave, you have effectively terminated my employment. Then we can require them to pay you severance and we can get you EI. So for now, because we're already almost at January 31st, let's see what happens January 31st. One of two things will happen. Either they'll bring you back, in which case, let's just forget about it, go back to work. If they don't bring you back, I think it's time at that point to simply say, no, I'm treating this as a termination, and now you have to pay me severance, and we can help you get EI. Now, you can't do that on your own. You'll have to contact us. So if you're not back on January 31st and you don't want to just sit at home waiting, contact my office through employmentlawyer.ca, and let's get to work. Okay, let's see. Randolph on YouTube. Can an employer change financial compensation as a result of vaccination status, like changing your commission percent. No. If they do that, that's a constructive dismissal. So if your employer changes your compensation structure, your compensation amount, you may be able to treat that as a constructive dismissal and get severance. So if you're in that situation, Randolph, let's talk about it. Monzi, I get the sense that your law firm is very busy right now. We are. What is the average time to settle with an employer? The average time is 2 weeks to 3 months. Okay, anywhere between 2 weeks and 3 months. 90% of cases are going to resolve. So next, I'll take the one last question today. This is from Pramod Jules on Facebook. Do you have successful cases where you sued employer for the wrongful dismissal and have the employee reinstated? So first of all, you cannot get an employee reinstated. So once wrongful dismissal, the remedy is to get compensation, to get damages, severance. You cannot get the employee reinstated. There's nothing that the law provides to get the employee reinstated, so that's not going to happen. Yes, but we've settled hundreds and, well, if you're asking about wrongful dismissal, thousands of cases. So we've settled 99.99% of the cases that we've taken on. So that's how it works, whether it's vaccine related or not vaccine related. Guys, for today, I do have to end it a couple minutes early. That's the time that we have today. I know there's more questions, okay? But if you didn't get your question answered, that's okay. Let's connect off social media. Just go to employmentlawyer.ca, okay? Employmentlawyer.ca for all the contact information, and we'll get together and have a discussion at that point. Guys, my name is Lior Samfiru. I'm a partner with Samfiru Tumarkin LLP. You can always connect with me through employmentlawyer.ca. Thank you so much for your time today, okay? I'll be back next week. Please don't wait until then. Just go to employmentlawyer.ca. Thanks, everyone. Have a good one.